Good day, sir. I am Callora and I am the third reporter in Group 4. In this video, I will be explaining my assigned topic, which is the continuation in the previous reporter. So now I am going to discuss other cybercrimes. So first, we have cyber squatting. Cyber squatting is the acquisition of a domain name over the internet in bad faith in order to profit, mislead, destroy reputation, and deprive others from registering the same. Cyber squatting act ni siya which is magpa-register kag usa ka domain name sa internet with the intention of profiting from it, misleading others, makadamage sa reputasyon sa usa ka tao, or it can be preventing others from registering the same domain name. Let's say, for example, na usa ka sikat nga brand clothing called Fashion Fusion, and it is registered in the internet as fashionfusion.com. And kani nga brand is naa sila registered trademark for their brand. So in this scenario, ang usa ka cyber squatter magpa-register pud siya similar domain name which is the fashionfusion.com. Iharang giilisan og usa ka letter imbis fusion nahimo siyang fusion. So gibuhat ni sa cyber squatter with the intention of misleading users and profiting from the similarity to the original brand. So in this case, there's possibility that the original brand will face financial losses and damage to the reputation of their brand kay ma-mislead naman ang mga users or customers. So how can we consider nga kana nga domain name is cyber squatting? First is if such a domain name is similar, identical, or confusingly similar to an existing trademark registered with the appropriate government agency at the time of the domain name registration. So there is a similarity of an existing trademark. If kana nga domain name has already a registered trademark, then it is considered as cyber squatting. Second is identical or in any way similar with the name of a person other than the registrant in case of a personal name. So there's a similarity to a person's name. If the domain name of a person other than the registrant, it can be considered cyber squatting. Third is acquired without right or with intellectual property interest in it. So now let's proceed to cybersex. Cybersex is the willful engagement, maintenance, control, or operation directly or indirectly of any lasciviousness, exhibition, or mga malalaswang palabas through the use of a computer. So it is also a communication between people using the internet that makes them sexually excited. Now let's proceed to libel. Libel refers to the act of making false and damaging statement about someone in written or printed form, such as through articles, posts, or publications. We should remember that in libel, the provision applies specifically sa naggama or nagpost jud mismo ana nga statement, or shall I say the author. So dili malayable sa libel those individuals who received the post or those who reacted to it. Libel as defined in Article 355 of the Revised Penal Code as amended, committed through a computer system or any other similar means which may be devised in the future is punishable by prison correctional in its maximum period to prison mayor in its minimum period, or a fine ranging from 6,000 pesos up to the maximum amount determined by court or both, in addition to the civil action which may be brought by the offended party. Now let's proceed to other offenses. So we have here aiding or abetting in the commission of cybercrime. This offense refers to the willful act of abetting, aiding, or financially benefiting from the commission of any of the offenses listed in the Cybercrime Prevention Act. A person who knowingly assists or supports another person in the commission of cybercrimes, except for child pornography and online libel, can be held liable. Next is attempt to commit cybercrime. This offense pertains to the intentional attempt to commit any of the offenses listed in Cybercrime Prevention Act. So if a person willfully tries to engage in cybercrimes, excluding child pornography and online libel, they can be held liable. Next, enforcement and implementation. The enforcement and implementation of the provisions of the Cybercrime Prevention Act are entrusted to two main agencies, the National Bureau of Investigation and the Philippine National Police. These agencies are responsible for ensuring that the provisions of the Act are enforced efficiently and reliably. To effectively handle cases related to violations of the Cybercrime Prevention Act, both the NBI and the PNP are required nga mag-establish sila og mga dedicated divisions or teams which is specifically focused on cybercrime. And kana nga mga divisions or teams kinahanglan nga ang ilang ibutang nga staffs kay katong mga special investigators who have expertise in handling cybercrime cases. So both NBI and PNP has a cooperation. The role of the National Bureau of Investigation is to establish a cybercrime branch that will be led by at least one head agent. This branch will be responsible for investigating and addressing cybercrime cases, while the Philippine National Police is required to establish an anti-cybercrime unit that will be led by at least a police director. This unit will be responsible for handling cybercrime cases and ensuring the enforcement of the Act. So, to coordinate the efforts of the NBI and the PNP in enforcing the provisions of the Act, the Department of Justice Office of Cybercrime or the OOC was created. The OOC serves as the coordinating body which is responsible for ensuring effective collaboration and cooperation between the NBI, PNP, and other relevant agencies involved in combating cybercrime. So now let's proceed to powers and functions of the PNP and NBI. The NBI and PNP Cybercrime Unit or Division shall have the following powers and functions. First is to investigate all cybercrimes where computer systems are involved. So the PNP and NBI cybercrime units is na authority nga mo investigate sa tanan nga cybercrime where computer systems are involved. Next is to conduct data recovery and forensic analysis on computer systems and other electronic evidence seized. They are empowered to conduct data recovery and forensic analysis on computer systems and other electronic evidence seized during investigations. They also provide technological support to investigating units within the PNP and NBI, including assistance in search, seizure, evidence preservation, and forensic recovery of data from crime scenes and systems used in cybercrimes. They may also provide testimonies in legal proceedings. The units also develop relation with the public, private sector, and other law enforcement agencies to effectively address cybercrimes. The unit also maintain necessary and relevant databases for statistical and monitoring purposes related to cybercrimes. They also develop the necessary capacity within their organization to perform duties essential for the enforcement of the Cybercrime Prevention Act. The unit also support the formulation and enforcement of the National Cybersecurity Plan. Next is they also perform other functions as may be required by the Act. So what are the duties of law enforcement authorities? The law enforcement authorities, including the PNP and NBI cybercrime units, have specific duties outlined in the Cybercrime Prevention Act. First is to ensure that the technical nature of cybercrime and its prevention is given focus. So they must ensure that the technical nature of cybercrime and its prevention is given due attention and consideration in their operations. Second is to submit timely and regular reports. So they are required to submit timely and regular reports including pre-operation, post-operation, and investigation results to the Department of Justice or DOJ Office of Cybercrime. These reports are reviewed and monitored by the DOJ to ensure effective enforcement of the Act. So let's proceed to preservation and retention of computer data. According to the Cybercrime Prevention Act, service providers are required to preserve and retain certain types of computer data for a specific period of time. So in traffic data and subscriber records, service providers must keep, protect, and maintain the confidentiality of traffic data and subscriber records for a minimum of 6 months after the purchase. So in content details, service providers are also required to store content details for 6 months from the date of issuance of a request from law enforcement agencies. So enforcement authorities have the power to issue a one-time extension of 6 months for the preservation of computer data. The service provider is notified of this extension by providing them with a copy of the transmittal document to the office of the prosecutor. This notification serves as a reminder to the service provider to preserve the computer data until the final termination of the case or as ordered by the court. It is important to note that the service provider is required to keep the order to preserve computer data and its compliance confidential. This means that the service provider should not disclose the existence or details of the preservation order unless required by the court or as part of the legal proceedings. Next is collection of computer data. According to the Cybercrime Prevention Act, law enforcement authorities have the authority to collect or record computer data associated with the specified communications transmitted through a computer system. This collection or recording can be done by technical or electronic means. To carry out this process, law enforcement authorities need to obtain a court warrant, which is a legal authorization issued by a court. Once the court warrant is issued, it grants the law enforcement authorities the power to collect or record computer data that is relevant to the specified communications. So the purpose of this provision is to empower law enforcement authorities to gather the necessary evidence and information related to cybercrimes. By obtaining a court warrant and collaborating with service providers, they can collect or record computer data that is crucial to their investigation. Next is disclosure of computer data. Following the receipt of a court warrant, law enforcement authorities shall issue an order requiring any person or service provider to disclose or submit subscriber information, traffic data, or relevant data in his or her possession or control within 72 hours of receipt of such order in relation to a valid complaint officially docketed and assigned for investigation by law enforcement authorities. Next, search, seizure, and examination of computer data. When a valid search and seize warrant is released, law enforcement officers may still have the following rights and responsibilities. First is to perform interception as stated in these rules within the time period specified in the warrant and to search and seize computer data, secure a computer system or a computer data storage medium, make and retain a copy of those computer data secured, maintain the integrity of the relevant stored computer data, conduct forensic analysis or examination of the computer data storage medium, and render inaccessible or remove those computer data in the accessed computer or computer and communications network. Next is destruction of computer data. So both service providers and law enforcement authorities are required to destroy the computer data in their possession in accordance with the order or warrant for retention and analysis. This should be done immediately and completely upon the expiration of the specified periods mentioned in sections 12 and 15 of the Act. Alternatively, the data may be destroyed upon the full termination of the case or as ordered by the court. And one thing that we should remember, that any evidence gathered without or beyond the scope of a valid warrant is inadmissible under any court or tribunal proceeding. The rules of court would be used in addition to the act in administering it. That's all, sir, and thank you.